Hi, I'm Sam Issacharoff. I'm a law professor at NYU in New York City, and I'm here at the Strings Pavilion at Steamboat Springs, Colorado. Tonight, I am the speaker at Seminars at Steamboat, which is a wonderful program running 23 years now, bringing really interesting talks, mine perhaps to the side, to this community, beautiful community, wonderful here in the summertime. My talk tonight is called The Constitutional Underpinnings of Democracy, and it's basically about the problems that democracies around the world are facing in maintaining capable government and maintaining their institutions in a new and much more difficult era. That'll be my talk tonight, and I hope it's enjoyed.
Good evening and welcome to the concluding seminar of the 23rd season of Seminars at Steamboat. I'm Mitch Wallerstein, the board chair of Seminars at Steamboat, and I can't think of a more important and timely topic than the one we will be considering tonight. We are honored to present Professor Samuel Issacharoff, the Reiss Professor of Constitutional Law at the New York University School of Law, who will be discussing the constitutional underpinnings of democracy and the role of the courts. Hardly a day seems to go by without news of yet another lawsuit or a new judicial decision related to the policies or actions of the current administration. There are reportedly now more than 140 pending lawsuits on matters ranging from the rules for deportation of undocumented immigrants to the removal of executive branch officials and the termination of entire federal agencies to various important environmental matters. What is particularly noteworthy about the current situation, however, is that the courts are being called upon to adjudicate fundamental challenges to many constitutionally mandated aspects of our democratic process. And often they are being forced to function as a guardrail, protecting constitutional rights and congressional mandates and authorities because the Congress has been unable or unwilling to act. According to the U.S. Constitution, the three branches of our government, executive, legislative, and judicial, are to be relatively co-equal in their power and authority. But that is not how things appear to be working at the present time. As a result, the topic we address this evening might be considered controversial to some, and it is therefore an excellent one for the seminars to be addressing. So we ask for your forbearance as Professor Issacharoff examines the causes and consequences of the current situation and offers us useful insights and information regarding how the U.S. Constitution underpins our democracy and the role that the courts play in this process. As most of you know, it is the stated mission of Seminars at Steamboat to present nonpartisan talks on a range of current public policy issues, both domestic and international. We strive each year to present an eclectic mix of topics, all of them focused on timely and important issues that are currently before the country. And in fact, the seminar's board just met last week in a brainstorming session to begin working on the program for the summer of 2026. On behalf of the board of directors of Seminars at Steamboat, I want to express our sincere thanks and appreciation to everyone who has donated to Seminars at Steamboat this summer or during the year and helped to make this unique discussion series possible. Your support enables us to bring these impactful presentations to the Steamboat community free of any admission charge. The sponsors of this week's seminar is the sponsor, I should say, singular, is one of our founders, the distinguished Brookings Institution economist, Isabel Sawhill. And the co-sponsors are Abby Meiselman and Ken Bloom, and Patricia and William Murray. As I noted, donations help keep seminars free of charge. You can contribute by going to the seminar's website, or you can also now use Venmo. QR codes for both methods are also printed on the back of your program. And if you or your organization is interested in sponsoring or co-sponsoring a seminar for the 24th season next summer, you can find information on the website in the donate section about how to do that. And now it's my pleasure to introduce the moderator of tonight's seminar, Abby Meiselman. Abby is a member of the board of directors of Seminars at Steamboat, and she is just the right person to serve as the moderator for tonight's seminar. She is a lawyer who, by coincidence, earned her JD degree at the NYU School of Law, the same institution where Professor Issacharoff is now a member of the faculty. Abby served as a federal prosecutor in the U.S. Attorney's Office for the Southern District of New York. Over the course of her legal career, she also held senior in-house roles as a litigator and a white-collar defense lawyer at various financial institutions. Please welcome Abby Meiselman, who will introduce tonight's speaker and moderate the Q&A session that follows. Thank you.
Thank you. That's good. Great, thank you. Mitch, thank you very much for that kind introduction, for setting the table so well for tonight's conversation. And thank you all for coming tonight to hear what I'm sure will be an engaging and lively conversation. It is my privilege to introduce Professor Samuel Issacharoff to seminars tonight. He is a leading figure in the study of democracy, constitutions, and the courts. He's a prolific author and has spoken extensively in both the United States and abroad. His most recent book, entitled Democracy Unmoored, Populism and the Corruption of Popular Sovereignty, and an earlier book that he wrote entitled Fragile Democracies, Contested Power in the Era of Constitutional Courts, are available in the back tonight if you'd like to purchase them, and he'd be happy to sign for you at the end of the program. As Mitch said, Professor Issacharoff's presentation tonight is especially timely. To state the obvious, we're living in remarkable times. Government, as we know it, is undergoing a radical transformation under the Trump administration. Some would say for the better, others would say for the worse. And our two-party political system is also undergoing a similarly seismic shift. This transformation has resulted in a huge number of lawsuits filed in courts across the country challenging President Trump's executive orders and other governmental actions taken since January of this year. Many of these lawsuits, brought by individuals, nonprofits, state attorneys general, advocacy groups, businesses, and universities, allege that the executive orders and other governmental actions are unconstitutional. And it's against this backdrop that Professor Issacharoff will discuss the constitutional underpinnings of our democracy, how the separation of powers among the executive, legislative, and judicial branches is intended to provide checks and balances, and how that system of checks and balances is actually working today. I expect you'll hear that at the heart of much of the litigation is the central legal question of the scope of presidential power and whether that power is intended to be as broad as the Trump administration contends, or whether there are limits on that power. Among the salient questions being litigated in the country, and there are many, are: does the executive branch have unfettered authority to impose tariffs under the Constitution, or is much of that authority vested in Congress? Can birthright citizenship, long considered to be protected by the 14th Amendment, be eliminated by executive order? What due process protections are individuals entitled to, even if they're in this country illegally, before they can be deported to another country? These are just a few of the many serious and complex issues being litigated across the country, including in the United States Supreme Court. Professor Issacharoff won't be able to address all of our pressing questions, but his presentation will deepen our understanding of how our constitutional framework supports our democracy, what the limitations of that framework are, and the unprecedented ways in which that framework is being challenged and tested daily. Please join me in welcoming Professor Issacharoff.
Thank you very much. Thank you. It's a great pleasure to be here. I spend much of my time addressing students and other academics, or going to courts, or addressing government officials in the US and abroad. And it's great to be able to talk to people who are just plain intelligent and interested. Doesn't always occur in the other settings. But let me also say a word of thanks at the beginning, which is, not only is it a pleasure for me, but you should appreciate how extraordinary this Seminars at Steamboat is. It's 23 years. My wife and I have a house in a town called Kent, Connecticut. And for about 6 years, we had an equivalent type event called Kent Presents. It was a great rallying point for the community. There were wonderful speakers, performances, all sorts of things. And it just took huge effort. And after 6 years, the people who put everything into making it work couldn't do it any longer. 23 years, that's a hell of a run, and you should be deeply appreciative of the people here. As I am. So, constitutional underpinnings of democracy. That's a kind of a misleading title, in a sense, because the introduction spoke about the Constitution, but you'll notice the Constitution is not the subject, it's an adjective. And it's being used. I will go over here away from that microphone, but I lost my clicker, sorry. So it's being used in two senses as a modifier, and that's still this. First, Constitution is obviously the Constitution itself, and when we talk about the role of the Constitution in our democracy, we're talking about the foundational legal document that everything is built upon. I don't want to spend time on this, but if you were to actually look at the text of the American Constitution, the one thing that really doesn't appear in there is democracy. The Constitution has almost nothing to say about how we organize our democratic processes. It has terms of limits on terms for the president, for Congress, for the Senate. It has a decennial census, so you can reapportion the population. After that, it didn't say much. And then we've had a series of amendments. We have the First Amendment on expression, and then we have several amendments that say you can't discriminate in who can vote, but they don't say how it's supposed to work. And that's both an omission and sort of in the nature of constitutions dealing with the fundamental questions of government, and that's what I'm going to speak on. But the second is that constitution also means to constitute. And what is necessary in order for democracy to work? What's necessary to be able to constitute a democracy? It may or may not depend on the words of the Constitution itself. It may, in fact, be a very different set of considerations. So, because I don't want more feedback, I'll move over here. Okay. So I'm going to start with democracy and not the Constitution, and then I'm going to circle back at the end of the talk to these two themes of what's the relationship between the Constitution as our text and the Constitution as the constituting of democracy. So let's start with democracy and where the world is now. This is a financial magazine that was talking about 2024 and said that was the year of democracy. That was the year of the elections. 85 countries elected their governments that year, more than had ever happened before. A bigger part of the world's population was engaged in democratic decisions as to who would run their states, and more than ever before. So it was a triumphant moment. And out of these elections, important things happened. First, across the world, with the exception of Mexico and the partial exception of Taiwan, we threw the bums out, right? That's the ultimate, if you want to know the definition of democracy, it's simple. Can you throw the bums out? Can the people, if they don't like who's in charge, get rid of them? And country after country after country, the incumbent powers lost. Even where they held on, as with Modi in India, they were much diminished because there was popular anger, there was mobilization through social media. People are unhappy with the way government works. So we had a change of administration in the United States, we had a change in many, many countries around the world, and that was characteristic number one. Second, in our era of populism, there's a lot of attacks on elections, election fraud, things of that sort. In 2024, amazingly, even in countries where the election system was deeply under attack, it worked. And we have pretty good confidence that the person or the party who got the most votes actually got into office. And so that's a triumph. That's a great thing. The election system worked and it yielded the results appropriately. But the third thing, and that's where I'm going to begin, is we're not quite sure who got elected. By that I don't mean we don't know which candidate won. We just don't know exactly how that fits into the way that democratic systems operate. So let's start with the way that we organize politics, which is through political parties. So what's the sense of who got elected? Well, let's start in the United States. This is the net favorability of each party right now in the United States. You'll notice it's underwater, meaning more people have an unfavorable view of the party than have a favorable view. The lines are basically how do you measure that delta, the net difference between the two. And most of this is survey evidence. Surveys are always suspect, and you should never put too much stock in survey results unless the same question is asked year after year after year. And then the trend lines are important, even if the instrument is imperfect. And there's no question that I can use this. Whoops. Okay. Now what? Here it is. You can see that over time, we used to have favorable views of our political parties, and in the last 30, 35 years, it's gone underwater. And what's happened? Why is that? Well, because we have a massive shift in what our political parties represent. So people who make less than $50,000, they have moved decisively to the Republican side of the aisle. That used to not be the case. People who make under $100,000, same thing. The group that has moved to the Democratic Party, which used to be labeled itself the Party of Working People, are those making over $100,000. So we've had a sociological inversion in our political parties. And if you just take a look at the Democratic Party, for example, because this is, I could do the same thing with Republicans, but this is quite dramatic. What you see is that among non-college whites, that is working class white people, they used to be up in the 1950s, close to 90% Democratic, and now they're just about 30% Democratic. So this is a huge change in the sociological composition of our political parties. And we're seeing it actively across all sectors of the society. So Latino males between 2020 and 2024, you see the massive decline in their vote for the Democratic Party and the dramatic increase in the vote for the Republican Party. Again, this is very recent and a very important change, so that I used to live in Texas. President Trump carried the Valley of Texas. When I lived there 25 years ago, that would have been inconceivable. This is very interesting, but let me explain it because it's not self-evident. But if we want, we can stop and take a quiz. No, it'll just... So I want to point out two features to you. This is 4 quadrants. depending on education and income. And you see low education, low income is the bottom left quartile. Here we have high education, low income. This is students, graduate students, permanent graduate students, people like that. And then high education, high income, etc. If you look at Bob Dole in 1996, this is the last typical election that we had, the way that the parties were constituted. What you see is his median support is right smack in the upper right quadrant, high income, high education people. And he lost to Bill Clinton, whose support was centered in low education, low income people. I don't mean that pejoratively, I just mean these are working people or poor people, and that's who the Democratic Party appealed to, and the Republicans are in the upper right-hand quadrant. Now let's look at 2024. And what you see is who is down in this quadrant? Donald Trump, the Republican candidate. And who is up in this quadrant? Kamala Harris, the Democratic candidate. The parties have flipped where they are. Trump is running to the same electoral base as Bill Clinton, and Harris is running to the same electoral base as Bob Dole. This means that by the time President Trump gets elected in 2024, there's been this transformation, but it hasn't stabilized in our politics yet. We have to see how this will play out. And obviously, Vice President Harris lost, but she also was representing a very different type of coalition than we would have expected from the Democratic Party some years back. And then you see on the Democratic side why this is so. Democratic politics increasingly organized around progressive ideas, progressive activists, and you see that they are not in sync with, certainly conservatives, but they're not in sync with blacks and Hispanics. They're not in sync with what used to be the core of the Democratic coalition. So on questions like America's the greatest country in the world, white progressives have a very negative view, but you see that black Americans, more than 50% say yes, Hispanics, 75% say yes, white conservatives, 85%, 90% say yes, and you see the gulf. Racism is built into our society, and here white progressives overwhelmingly so, much more so than blacks, and certainly much more than Hispanics. And these other questions, border security, we have a whole series of these kind of surveys, and it comes out the same no matter what question you ask. There's a gulf between the activist core of the Democratic Party and what its new social base is. And then the question on the Republican side is a little more uncertain, but we'll come back to that. Now, why is that important? Because political parties are not just about putting candidates up for office. Political parties actually organize our government. They make things work. They propose legislation. They get things done. And if the political parties no longer represent the constituency that they did, how easily are they going to translate this into governance? How well are they going to do, not in terms of getting candidates elected to office, but in terms of getting something done with them? Can government work? And so one of the things that's apparent, and this is sort of a summary from the prior slides, is that people don't like the political parties very much. They don't identify very strongly with them. And so you see that it used to be that 35% identified with each of the major parties, and you had a much smaller group that was labeled itself independent. Political parties, they're both around 28% now of the population, of the electorate that identifies with them. The biggest share is people who are so-called independents. Whether they're really independents or not, we can debate. Each party thinks that anybody who labels himself or herself an independent is really a snake for the other side, and so not to be trusted. But nonetheless, it's, again, over time, it's an increase, and over time, this is an important decrease. Now, what happens then is that you don't have a party apparatus in place. And so when you don't have a party, who's going to determine which bill goes forward? Who's going to thrash out the compromises? Who's going to get things done? And there's a quote from a political scientist, Seth Maskett, that says, a partyless legislature is a collective action nightmare, which means it's going to spin off in all sorts of directions. And the illustration is simply the Republicans going through endless cycles of trying to pick even a Speaker of the House and not being able to select one. I will have something on the Democrats in a moment to make the same point. And so what's the result of that? Well, if we go back to the 1970s, Congress used to pass something on the order of 400 pieces of legislation a year. 400 per year, 800 per two-year cycle of each Congress. And over time, that has been going down to the point that it was, in 2019, it was less than half. So Congress is passing 300 and something per year in 2019. That's going to seem like the good old days. Congress in 2023 passed 22 pieces of legislation. It used to pass 400 a year. So they had a lot of debates, a lot of votes, and nothing happened, starting in 2022, 2023, 2024. Congress is AWOL. It's just not functional. And the result is that even those numbers exaggerate what Congress is doing. Because if there are political scientists who divide legislation between what's substantive and what's ceremonial, and I'll get to examples of each, but you see that a substantial amount of the legislating that's being done is in fact ceremonial. And what's an example of ceremonial? This is one. It's to change the name of a South LA post office to the Marvin Gaye Post Office. Now, I know I'm supposed to be nonpartisan, but let me just say, I fully endorse this. I'm a big Marvin Gaye fan. This was an important act, and it was well merited. So don't take it away. But really, that's why we spend all this money on elections? By contrast, this is Congress creating something substantive at the beginning of the Biden administration, the Infrastructure Act. $1.2 trillion. That's a huge piece of legislation by any account. But what did we get for it? This is a picture of a modern immigration processing facility that is going to be built at the Arizona border. It's a nice picture, and in fact, this billboard is the entirety of the construction that has been done on this facility. And so, yes, Congress can legislate, but they don't put into effect something that can get the results that people need. So, near my house in Connecticut, there's a complicated approach onto the interstate, and it's always messy there and stuff. And there's a sign up by the side of the road. These improvements were brought to you by the Infrastructure Act of 2021. Well, they were in some sense because that sign wasn't there before. But it's not exactly what you want to write home about. So take, for example, and I know this is now all up for reconsideration under the Trump administration, but my point is not to endorse one side or the other. My point is, can you get it done? And so Congress awarded $100 billion for alternative energy sources, clean energy sources. And of this, as of 2 years after it was passed, what you see is that 20.2 billion out of 100 had actually been dispersed. And almost $80 billion just remained because we don't have shovel-ready projects. We don't have the ability to do these kinds of tasks any longer in the United States. And if you actually break down where the $20 billion went, what happened, and this is the part that deals with wind energy construction, that you see planning, site control, permitting, nothing is even at the approval stage, let alone operational. So 2 years later, there was a exact identical amount, 42 megawatts of operational offshore wind production. No gain as a result of the massive legislation and as a result of the spending, even of the initial $20 billion. Now, why is that so? Well, this goes back to the point, and this is true. I'm focused on the ones that have had some track life so that we can make observations about them. I would say the exact same thing about the big, beautiful bill of President Trump, which is when you don't have political parties, it means that the party leaders, the committee chairs, and the minority members can't can't negotiate to get the bill that they need. So what they end up doing is they create the bill, and then they create a coalition to back that, item by item by item. So when I say we only have 23 bills that passed in 2023, what that means is that the bills that pass are these gigantic bills that look not like a piece of legislation, but like a Christmas tree. Lots of ornaments, lots of babbles, lots of things that were put there in order one by one to get vote. So let's just look at the Clean Electricity and Transmission Acceleration Act of 2023. In order to get the Democratic coalition, this is when you had the Democrats in office, what did you have to do? You had to have considerations for aesthetic, historic, cultural, economic, social, or health effects of just building more power grid capability. You had to authorize community benefits. You had to offer funding. Now this is one that, for lawyers it's great because it's a Full Employment Act, but you had to fund under the National Environmental Policy Act lawsuits to challenge the development that you were trying to propose. Judges were required to look to the impacts on environmental justice communities. This is obviously a distributional question toward minorities, which can be fine as a matter of policy, but does it have to be in every single piece of legislation? And is this the one where you necessarily want to have redistribution, which every government has to do? And it limits agency actions that cause or contribute to overburdened communities defined by race, poverty, language, minority status. All that to build a power line, right? That's a recipe for getting nothing done. And that happens when you cannot have political parties with authority in the Congress to say, this bill, we will do this, and we will give you something else someplace else. We will trade off over time. Instead, every piece of legislation that passes, whether it's the Infrastructure Act or the Big Beautiful Bill, has to have special constituencies. If you want to go to the Republican side of the aisle, we have a provision in the Big Beautiful Act for protection of whaling captains, right? And that's, I read Billy Budd, I read Moby Dick, I'm all with it. But it's not what you would think would be the centerpiece of an administration in 2025. Now, this theme is very big in the news right now, and there's 2 books out that get a lot of play right now, Abundance by Ezra Klein and Why Nothing Works by Michael Dunkelman, and they talk about how in order to build consensus for these things bill by bill, you have to layer in due process, you have to layer in review, you have to layer in environmental impact statements, and by the time you layer all this in, it's impossible to get anything moving. And that's a significant problem, which I want to tie back again to the collapse of political authority in our country. Take immigration, for example. That's the clearest one. We all know the problem. The numbers are staggering, how quickly it's gone up. And it's kind of interesting that every time that the percentage hits about 15%, so it did that in the 1920s and again in the 2020s, every time we hit about 15% foreign-born, there seems to be a nativist reaction. We closed the borders. We didn't allow immigration in the 1920s. And again, let me be clear. I'm an immigrant. I was born in Argentina. Some of my best friends are immigrants. I'm not here to, but it's just, this is an issue. And it's an issue of policy that we have to confront. There is no appetite in our congressional leaders on either party to take up the question of immigration, which is probably one of the most pressing social issues and economic issues in the United States right now. We just can't get it done. Okay, so what does all this mean? Now let me tie this back, and I'm going to bring this back to the Constitution at the end. So the median US voter is still pretty moderate. It's not like we have a polarized country where there's nothing in between. In 1991, roughly 40% would have identified themselves as moderate. In 2021, it's about 35%. It's not that different. We still have pretty similar distributions of how people think of themselves politically in the United States, but our politics is clearly more fractured, it's more polarized. So what's happening? Well, in Congress, the parties have moved further apart. And you see that from the 70s over here to the 2020s, the Democrats and Republicans in the House and the Senate have moved apart from each other. You no longer have any Democrats and Republicans with overlapping voting patterns. You have sharp divisions between the parties, and they have moved not only away from each other, but away from the center. The Republicans more so than the Democrats, but nonetheless, they have each moved closer and closer to the polls, which is something that would not have been predicted by theories of how voting behavior influences candidates, that they always have to run to the median voter as it is. It doesn't happen anymore. They run to the polls. And let me show you why. And let's take as an example the 2021 mayoral election in Buffalo, New York. There's a primary in the Democratic Party. Buffalo is a one-party town. Like many medium-sized cities, it is controlled by only one party. There is no effective Republican Party in Buffalo. In the mayoral election, the winner was a socialist, right? Endorsed by AOC, endorsed by the kind of the extreme left of the Democratic Party. The incumbent was a moderate Democrat, not particularly inspired from what I can tell, but he was a moderate Democrat. He gets defeated in the primary by a socialist. Now, it seems that people here are old enough to remember days when no incumbent ever lost in a primary, right? So that losing to a socialist in a primary, wow. Well, how does that happen? Well, if you look at the primary results, you see that Walton, the socialist, got 50.5%, just barely, and Byron Brown, the incumbent, got 46%. Now that meant that Brown, under Buffalo laws, Brown could not run for any other party. They have the spoiled loser effect there, and so he couldn't run. The only way he could run in the second round was as a write-in. There was no Republican candidate, so Walton was in the election unopposed. But now look at what happens in the general election. In the general election, all of a sudden, Brown as a write-in gets 60%. Why does that happen? How can it be that between this election and this election, which is only a short period of time apart, you have such radically different results? Well, the answer is you have different electorates. In the primary election, 23,000 people voted. In the general, almost 3 times as many voted. In the primary election, voter turnout was 15.5%, general election 40%, which is not particularly good, but not that off for an American local election. So when you hear people talk about the term to be primaried, what that means is not only that you're challenged by somebody who is further to the left if you're a Democrat, further to the right if you're a Republican, but it means you're running in front of a very small group of people. And the people who turns out in primary elections, it's the activists, it's the extreme wings of both parties. And so the reason that the Democrats and Republicans in Congress move apart is that they're worried about their electoral constituency, not in terms of the median voter, not in terms of the general population, but in terms of this group that will actually turn out. Now, this is not just the United States. This is going on all over the world. The parties are losing their control. And so I just came back from Poland. In Poland, if you look just at the last presidential election, it looks like an American presidential election. Really, really tight. The conservatives, the PiS, narrowly beating the incumbent party, the party that holds the prime ministership at present. And that looks like the typical story of division. But it's not. Because what this is really about is an artifact of the second round, where you only have the top two running. In the parliamentary elections in Poland, when you look, what you see is that there is no party with much control. What you have instead is far-right parties getting increasing percentage of the vote, and so that when you get to the presidential election, sure, you will elect a president, but it's harder and harder to control politics, to get things done through the parliament. And that's a parliamentary system. United Kingdom, last elections, wow, huge win for Labour. They ran the tables on everybody else. But that's only because of the way the seats are assigned in Britain. Labour won only a third of the votes. Labour and the Tories together barely got 50% of the votes in Britain. In Britain, it's inconceivable that Labour and the Tories, that's the two parties that have defined British politics for 100 years, and they get half the votes. In France, the entire post-war period was the Gaullists and the Socialist Party. Both have disappeared at this point. And so when we look at this, we see that there is this fragmentation, this fracturing of political authority all over. And if we look at country after country, the two left columns are the far left and the far right. You see the tremendous political pull that they have in France, in Germany. Poland is a little bit more complicated because of how you characterize peace. Romania, you see that there is the far right is basically the ascendant party and will be the second party in the parliament in very short order. Why is this important? Well, let's go back to the fear that everybody has to go through when you see democracies in trouble around the world. Let's go back to 1928 in Germany. And one of the things that happened in Germany was that you had the Socialist Party as the biggest bloc. But look at how many parties there were, how fragmented political authority was, how incapable the Reichstag was of legislating, of getting things done. And the result was there is a provision of the Weimar Constitution, Article 48, which says that the president, the president has the right to declare an emergency and to pass legislation by presidential decree. And so between 1925 and 1930, this was Weimar democracy. It was messy, but it was never used. Between 1930 and 1932, you see that everything was being done by executive decree, not by ordinary legislation, by executive decree. Keep this figure. You recognize what's coming. Keep this figure in mind. And so what you also see is that between 1930 and 1932, the Reichstag became so inconsequential that it didn't meet. It didn't do anything. It didn't pass any laws. Uh-oh. The parliament didn't pass any laws. So what does that do to us here in the United States? Why is this a warning? In the last two successful presidential campaigns, look at what the candidates vowed that they would do on day one. I will immediately reissue my executive orders, restoring the president's authority to remove rogue bureaucrats, and I will wield that power very aggressively. Executive order. On day one, Biden will sign a series of new executive orders with unprecedented reach, et cetera, et cetera. They're not talking about legislation. They're not talking about how they want the democracy of our country to respond. They're talking about unilateral executive power, the same thing that actually took hold in Germany. And so ever since Franklin Roosevelt, we've measured our presidents by their first 100 days. And we say, how many pieces of legislation did they pass in their first 100 days? Obviously, presidents don't pass legislation. Congress does. But you see that Roosevelt was up in the 75. He came in with a package of statutes. He had a Congress that was willing to do it. There was a sense of emergency out of the Depression, and they got it done. Truman, less so. And then after time, it starts to go down and down and down. And the one exception is Donald Trump in 2016, but we'll see in a second that that's not really pieces of legislation. There is, when the president controls both the same party presidency and the Congress, they can fast track overturning of prior actions by the prior administration. So it's a little bit of a cheat because it doesn't have the filibuster rule, it doesn't have any of the normal processes of standard legislation. So in the first 100 days, by contrast, if we say the sum of executive orders, memoranda, proclamations, because we have to take into account that we use social media now to govern, you see that FDR was everything. I mean, he was a force. He just was transformative. But after FDR, it's very hard to get things done. It's very hard to get things done in the first 100 days. One reason is, even though Biden said, I'm going to hit the ground running with all these executive orders, you can't do it. In order to issue an executive order as president, you have to run it through White House counsel first. Then you have to run it through the Office of Legal Counsel, the Department of Justice. You need legal opinions to make sure it doesn't contradict other executive orders and it doesn't somehow compromise the workings of government. On day one, you don't have an attorney general. You don't have a White House counsel. Those are Senate-approved positions. You don't have a head of Office of Legal Counsel. Again, that's a confirmed position. And so as a result, you can't issue many executive orders unless they're based exactly on pre-existing executive orders. President Trump, if you'll recall, on day one, he goes to the inaugurations balls. There are several of them. He went to them. And then he goes to the D.C. Convention Center. And he has a table there. And he starts signing executive orders by the dozens. Who vetted those? Who checked the legality of it? Who checked to see whether they contradicted prior executive orders? That wasn't done. So if you bypass those systems, you can get a lot more done. And you see this. This is a really dramatic effect. Now, before the quote, look at this. This really tells the whole story of how we govern right now, which is, remember, FDR, 80 pieces of legislation, 60 executive orders. That was the most of each that has ever been done. And now you look at every administration, and they get very little done in terms of legislation, an increasing number of executive orders as a way of governing. And you see the steady progression. Trump 1 was more than Obama, and Biden was more than Trump. But this number is completely unprecedented. and you put this together with 5 pieces of legislation in the first 100 days and 145 executive orders. That's how we govern right now. And what does this mean? It means that there's somebody missing in our democratic structure, there's somebody missing in our constitutional structure, and that somebody is the Congress. The Congress no longer is Article 1. It's no longer the centerpiece of democratic governance. And there's a very interesting comment made by Justice Kavanaugh during the birthright citizenship case, which really turned on the powers of injunctions of the lower courts. And he says, it seems that it might be, oh wait, the why. Why? The why was a reference to, why are we seeing all these cases hit our court right now? Why are we seeing all these appeals from injunctions? Why does it seem that the way that courts worked, which is we review the constitutionality of legislation, we don't do that anymore? Why? And Kavanaugh speculates, it seems why might be because it's harder to get legislation through Congress, particularly with the filibuster rules. Presidents want to get things done with good intentions. The executive branches that work for those presidents push hard to stretch or use existing authority that they've been pushing, understandably, all with good intentions. You may agree, you may not agree, but this is a judicious comment, right? He's saying with good intentions. All the presidents, both parties, right, with good intentions pushing. Is that your understanding of why this has happened more and that there's less ability to get legislation? And that's exactly what's going on. That the check on the presidency is no longer the Congress. It's now the courts. We have executive orders, and then we have judicial challenges to those. And that means in the first 100 days, we now have a new metric. How many lawsuits filed in the first 100 days? And, this is just stunning. And of course, these are activists and people who are upset about this or that, and some of these lawsuits may have no merit, but 220 lawsuits filed in 100 days? I mean, that's extraordinary. And it's a huge pressure on the courts because it's asking the courts to judge the constitutionality of executive claims to authority without congressional legislation as the backstop to figure out what should be. So we have, in this period, 330 lawsuits, and this was from the statistics from a month ago or so, 40 injunctions granted, 200 court orders, et cetera, multiple significant Supreme Court rulings, and in that same time, we have 5 pieces of legislation. 1 Immigration Act, which was semi-significant, 1 budget continuation, that's a big, beautiful bill. That's really all that has been done at the legislative level. 3 deregulatory repeals through the Congressional Review Act. That's what I described before as the fast-track undoing of regulations. And that's it. That's it. So if you were to look at what's going on from the vantage point of Congress, it's a non-player. Now, that gets to the conclusion and where the Constitution comes back in. The Constitution doesn't say much about the foundations of democracy, but there are 3 that I want to suggest to you. The first is the idea of repeat play, which is a term from game theory of economics. But what it basically means is what goes around comes around. If I'm on top today, I'm going to push for my advantage. I'm going to try to get things done, but I'm not going to push so far because tomorrow I might be on the bottom end. And so we kind of live within certain parameters as long as we have a long time horizon that we're all going to get our due. And that means that point number 2, in a democracy, the majority wins. It has to take command, but not too much. It can't put the minority in jail. It can't take away the rights to organize the minority. It can't stop political dissent. So there are boundaries, but the majority must win. Policy must go over to the hands of the majority. And historically, this balance is between institutional actors with long time horizons. So they see that we've been at this a while, this is an important way in which we do things. We don't push too far. This is not just the American tradition. This is the English tradition that we took this from. The 19th century Gladstone, English Prime Minister, says, we have an important constitution in Britain. It's not written, but it just means that men of good faith will do the right thing because we've learned how to do it. In the United States, the framers in the Federalist Papers spoke of the process of what they called liquidation. And liquidation meant we don't know exactly how things are going to play out, but over time we're going to work things out. And liquidation means that those settled practices become the way we do things. In the 20th century, Justice Felix Frankfurter referred to that as historical gloss, that we interpret the Constitution's silences through lived experience and institutional memory. That's how democracy works, and that's why our Constitution says little but leaves a lot of room for the right institutional actors to work out the balance. But let's figure out whether they are doing that. So in our Constitution, we have Article 2, Section 3. Article 2 is the executive, and it's the take care clause. The president shall take care that the laws be faithfully executed. And Justice Jackson, one of our great justices, in a famous concurrence in the Steele seizure case, says, when the president takes measures incompatible with the express and implied will of Congress, his power is at its lowest ebb. And more recently, Justice Gorsuch made the same point. If Congress could pass off its legislative power to the executive branch, the vesting clause and indeed the entire structure of the Constitution would make no sense. We are dependent in our constitutional structure on the legislative branch. The legislative branch depends on active political parties with long time horizons, and we don't have that. And so I'm going to finish by explaining two cases that are before the courts right now that are highly, highly significant in just this way. What happens when Congress doesn't do its job? So this is the tariff question. You've all heard that President, yes? Okay. Good. Again, it's a quiz. Don't feel bad if you failed, but ask yourself why. So the tariff question is really interesting because the Constitution expressly assigns, why do I keep doing that? Assigns the exclusive powers to lay and collect taxes on the Congress. But the Constitution itself, the tariff clause, is extremely peculiar. What it says is Congress shall have the power to levy tariffs and duties, and not the states. It was written as against the Articles of Confederation, in which every state had its own tariff authority, and foreign powers could play them off against each other. And so the Constitution says, we don't want this at the state level, we want it at the federal level, so Congress is going to have this power. It doesn't address the balance between the president and the Congress. And so then in the 1970s, which you may recall was the oil crisis and was the need to be able to respond more flexibly to seemingly an international trade collapse, Congress passed the Emergency Powers Act of 1977, and it says, any authority granted to the president may be exercised only to deal with an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States if the president declares a national emergency with respect to such threat. And then it has some regulations that go with that. Well, we were dealing with an emergency in 1977. There was a huge shock to our economy. We were in a period of inflation. It was a very difficult moment. Congress gave this power, but they said, unusual and extraordinary. Well, what is that? Who decides that? And who decides what those powers are that follow? Congress never said. And what has it done since 1977 with regard to this power? Nothing. Nothing. So right now you have a president who says, I declare that it's unusual and extraordinary right now. And I declare that there's a national emergency. Therefore, I'm entitled to impose tariffs at my will
of any amount I determine, on whomever I determine, for whatever period I determine. Well, maybe, but who should clear that up if that's not what Congress intended? It's obvious. You get a second piece of legislation that says, hey, wait a second, that was 1977. We're 50 years later. We're not dealing with that, and we're not giving you this power in perpetuity. Where's the Congress? It's gone. It's empty. And so as a result, now you have the courts trying to figure out how to interpret this with no constitutional text to rely on and no clear statutory authority. Again, our main problem, in my view, is the abdication of Congress and the failure of the political parties to discipline congressional act. Let me finish with the last one, which is the Alien Enemies Act of 1798. This is the statutory authority for the claim of the president right now to be able to deport foreign aliens without any process and without any enabling legislation other than the Alien Enemies Act. Now, when this first started, this litigation started, I'm reasonably aware of these things, but I read a brief and said, this is a power pursuant to the Alien Enemies Act. And I said to myself, what? What Alien Enemies Act? You're talking about Korematsu? You're talking about the Japanese detention in World War II that the Supreme Court and the executive has apologized for? And is that the statute? And in fact, they're relying on the statute from 1798. This statute was passed because the damn French were taking our seamen at sea and forcing them into the French Navy. So we were going to deal with France. We were going to show them that we were a country like all others and that we had the power to resist and to be able to protect our citizens, our fleets, and so forth. 1798. And it says, whenever there's a declared war, okay, we don't have declared wars anymore, and any foreign nation, government, or any invasion or predatory incursion is perpetrated, attempted, or threatened. Wow, that's beautiful language. That's some nice 18th century prose there. But what the hell does it mean? And what does it mean 230 years later, when all of a sudden what you have is old regulations that the president may prescribe such regulations as he may deem necessary and establish any others he shall find necessary for public safety? Well, maybe we're facing an invasion from Venezuela of refugees coming in. Maybe. And maybe this is an emergency, or maybe this is a predatory incursion that's being perpetrated. The courts now, the first level review in Southern District of Texas, the court concludes that the president's invocation of the Alien Enemies Act exceeds the scope of the statute and as a result is unlawful. Well, it's not so much that it's unlawful. It's not so much as it exceeds. It's, what are you talking about? This is not the French taking our seamen at the high seas when we didn't even have a navy yet. This is, it's a different setting, it's a different time. There's a simple cure to this, which is let there be serious hearings in Congress, let them debate what a bill should look like, and let them figure out what is the scope of the president's authority, for how long, and under what circumstances. That's how it's supposed to work. And it doesn't work that way. So let me go back to the beginning of where I began, which is we have a Constitution that doesn't say much about how this stuff is supposed to work. And we have a constituted set of practices which have deeply informed the very operation of our government. The problem is that the way it informs it and the way it controls, including what we call constitutional law, is largely by persuasion, is largely by, gee, that has worked, we're going to honor it. It turns out that when our institutions aren't working, that those assumptions become very weak. And that's the challenge of our democratic time. Now, I don't think that we're going to go back to the political parties of the 1950s and 60s that can pass 400 bills a year. I don't think that we're going to reconstitute the kind of political authority that we had 50, 60, 70, 100 years ago. We're obviously in a different time. We're obviously in a world of social media. We're obviously in a world where there's a lot more money coming into the political system through independent means. We have different challenges. But the constituted order is under serious disrepair right now. And I think that the Alien Enemies Act, the fact that we're debating the Alien Enemies Act of 1798, is an indication that we've gone astray. Thank you very much.
Thank you very much, Professor Issacharoff, for that fascinating discussion. I think I'd call it a hit parade of government dysfunction. Government by executive decree. So I'd like to hone in a little bit on some of the executive decrees. But before I get to that, I want to talk about the plane. By that I mean the airplane. I think everybody has followed the airplane saga. Under the Constitution, should Congress have held hearings and voted on whether President Trump could accept the plane offered as a gift by the Qatari government? As we know, the president plans to use that plane as Air Force One and then transfer it to his presidential library. So what are the implications of his acceptance of that gift in the absence of any congressional review or approval, especially under the emoluments clause?
Right, so the Constitution has a clause that says that there shall be no emoluments, which is a fancy word that just means you can't take money under the table. And it was intended to keep our public officials from being bribed. There were early scandals involving officials in both France and Britain being bought. And so over time, we have put some teeth into the emoluments clause, not so much by legislation, but by legislation combined with regulations, that is, by the executive branch recognizing that it has a duty to be honest and straightforward with the American people. So we have regulations that say if it's a gift more than $200, it has to go to the Smithsonian or has to go into the public trust. It has to be declared in all sorts of ways. This is self-policing in the way that I referred to earlier as Prime Minister Gladstone, as people of good faith recognizing that it's in everybody's interest. Sure, I would like to keep a good plane. You know, quite frankly, the flight from Hayden to Denver is no great shakes. I'd love to have a big private 747 to take me, but we'd all like that. But it's self-policing. And when somebody says, no, I'm not going to be bound by it, then all of a sudden you don't know how you're going to keep that in effect. And the problem is that it's never been thought that this was a point of contention. As a result, we've never tested constitutionally, can Congress tell the executive how to do this? That's not clear.
Right. Could Congress have insisted in this instance, you can't accept that plane until we've debated it and approved it?
I don't think that Congress, personally, I don't think this court would find that Congress has the authority to impose that on the executive. What Congress could do is hold hearings. It could be a sounding board. It could say, we are not going to approve budgets for the maintenance of the plane. It can do all sorts of things within its authority. Could it legislate against the president on how the president accepts gifts? That's not clear, and we've never had to test that. And what we're doing right now is we're testing all sorts of boundaries that have never been presented before, largely because where was the congressional hearing on the Qatari plane? Right? It didn't happen. Didn't happen.
Speaking of boundaries, I think a lot of people have been following some of these lawsuits, and people are wondering if the Trump administration were to defy a court order, how could the court enforce compliance with the order? And in your opinion, has the administration defied a court order to date?
So,
That's a serious question.
it's a serious question. So, two quotes to start with. The Pope denounced Stalin at one point, many years ago, over his conduct in Eastern Europe. And Stalin had a great quote, which was, "How many divisions does the Pope have?" Some time before, Stalin may not have known he was echoing one of our presidents, the Supreme Court and Congress both ordered Andrew Jackson not to wipe out the Cherokees in Florida, the Trail of Tears that ensued. And President Jackson said, Chief Justice Marshall has given his order, now let's see him try to enforce it. So we do have a tradition in the United States and abroad of, yeah, you got troops, then we'll talk. You don't have troops, then you're done. We've not had to confront that in the United States since Andrew Jackson. It is true that Lincoln didn't summon the Congress back when he started the hostility, when he responded to in the Civil War. It is true that FDR was already leaking information and material to Britain, even under the Neutrality Act. Both of them cleaned up their acts immediately by getting congressional approval. Since then, no president has tried to defy a direct court order. Now, to be fair, we haven't had very many court orders issued against the president. We had one against Richard Nixon over release of the papers and the tapes, and that was complied with. To date, the administration has walked the line on about a half dozen judicial orders, meaning that it has not complied in good faith. It has not expressly refused to comply. It has slow-walked it. It has taken actions depending on whether the plane took off or was in the air, depending on whether the judge had the authority to order a plane that's already in the air back to American space. All these are contentious points, but without taking a position one way or the other on any of them, all of them were going up to the line. So far, in my opinion, the administration has been careful not to cross that line. And in the oral argument in Trump versus Casa, which I quoted Justice Kavanaugh from before, the administration actually, the Solicitor General took the position in the Supreme Court, said, we will recognize categorically the authority of the United States Supreme Court to interpret the constitutionality ultimately of anything we do, and we will obey. And oddly, it was the first time a Solicitor General had ever made that statement in the Supreme Court. It had been understood, but it had never been said before. So far, they have not. What happens if they do? If they say, we're just not going to do it. We already have mobilized troops in D.C. as of today, and so we're all ready to go, and we're going to shut it down. Well, at that point, we may be in the domain of Stalin and Andrew Jackson. We may be in the domain of how many troops can you marshal? Who's the army going to be loyal to? That's the end. That's the end. We're not there yet, in my view. We're not near there. It's important to recognize that that's a threat, and it's important to recognize as well, I think, that it has not been realized yet.
All right, let's switch to law firms. Many people would be happy if a lot of law firms went out of business. President Trump particularly would like that. But there have been a number of executive orders directed at law firms, labeling them as national security risks because they represent political opponents of President Trump, or because some of the lawyers at the firms investigated President Trump in his first term. Could you explain the significance of these orders? Because law firms, I think we would agree, are really a critical component in our system based on a rule of law. And a number of the law firms that were the subject of these orders actually challenged these orders in court. Could you talk about how the courts that have considered the orders have responded and what the implications of that are?
So first, let me disagree with one thing, Abby. I think throughout his career, President Trump has been a full employment act for lawyers. So there's never a bad, slow day when you have a Trump involved. I once was supposed to take his deposition in litigation many, many, many years ago, private litigation. So you have the use. The federal government is such an enormous power in our society, and not just by what it decrees, but through its contract, through the size of its economic involvement. You cannot be a major law firm without dealings with the government. You have to be able to represent your clients in front of the government. You have to be able to negotiate various kinds of regulatory matters, all sorts of things, in the same way that universities can't survive without public funding. We can't do our research, we can't meet our budgets, we can't play our role in the society without a big component of federal involvement. Up until, I'm not going to say this administration, but up until recently, that has required a certain reticence on the part of the executive branch in using its muscle against these institutions, recognizing that a lot of the time they're a pain in the ass, we don't like what they do, but they're necessary for our society. This kind of individual by individual vendetta, firing individual lawyers in the Justice Department, or decreeing that because lawyers had played a role or represented a presidential candidate in a prior election, that they cannot function effectively, meaning you can't come into a government office, you can't negotiate with us, you can't represent clients before our agencies. That means you're out of business. And this is a power that has been used by this administration in a way that it has never before been used. Now, there were elements of this under the Obama administration. There were elements of this under the first Trump administration, under the Biden administration, but we've never seen anything like this. When it comes to the courts, it's a huge challenge conceptually, and I'm going to say why. The real problem is you shouldn't be doing this. This is not how things work. This is not how we built this country. We don't have exact legal categories for that. And so when it gets to the courts, people say, well, it's the First Amendment. The First Amendment, the right of expression. You're trying to circumscribe expression. It sort of touches on that. It doesn't capture it very well. The real point is you shouldn't be doing that because this country is better off that both sides in the dispute can be represented. This country is better off that candidates for office can be advised on what the boundaries are of what's legitimate. This country is better off because we fund basic research, even if most of our professors are useless idiots. We are better off for this. And the courts have looked with tremendous hostility at the law firm regulations in particular, but this has got a long way to go before it plays out.
Let me do one final question, and there are a lot of good questions that people have proposed. This is about the Roberts Court. We haven't talked much about the Supreme Court, but John Roberts has long been thought of as an institutionalist. How do you think the Roberts Court will be viewed over time in history?
I think that that page has not been written. I think that there are three justices of the Supreme Court that are clearly on the liberal left. Although it's a sign of our times that Elena Kagan, who's a centrist and a institutionalist by heart, is now on the left of the court. There are three justices who are pretty consistently on the right, certainly Justice Thomas and Alito, and on most matters, Justice Gorsuch. And then there are 3 justices who we just don't know yet because they have conservative views on many social issues and many questions about the boundaries of the court, but they also have this deep sense of protecting institutions. And so you saw the question from Justice Kavanaugh. I could show you similar quotes from Justice Barrett and from, of course, Chief Justice Roberts. If we continue down this path, if that chart I showed you, where it's all executive orders and no legislation continues, the courts are going to have to redefine the institutional arrangements of the United States. And they're going to have to start asking a question that they don't like to ask. And I'm glad you ended here, because it's really kind of the question of our day. The current court likes to ask the question, what was intended in the beginning? That's the originalist move. They feel most comfortable there. They feel that they have the greatest authority there and that they are able to engage as justices there. I think the question for today is, what do we need now? And they don't like that question because they don't think that that's the question the court should be answering. Unfortunately, the whole thrust of what I tried to present this evening is that increasingly it's the courts that have to be answering this question. And I think the legacy of the Roberts Court will be whether it successfully navigates us through that or not. If it fails, we will all fail.
I don't really like to end on the word fail, but thank you very much.
Thank you.